you can feel confident resorting to the courts of that country, I think our standard operating procedure and default would be to opt out.
Right.
I mean, there are plenty of courts in Europe, for example, or Australia or other developed court systems that we might feel comfortable with. But in the developing world, unless we have very specific information that the courts of Costa Rica are neutral and unbiased and procedurally adequate, such that they move things reasonably fast, we would normally opt out and go with international arbitration.
Right. Okay, well, listen, let me ask this then. When you choose arbitration, do you have any preferred places where you like to cite the arbitration proceedings? I imagine,
We like to cite arbitrations in countries with a well-developed set of arbitral laws, and in countries where the court system is likely to assist the arbitration in corollary matters but not interfere with the arbitration. The U.S. and Wales Act of '96, I think, is an example of a very good arbitration law.
Right. I mean, I guess this goes to your point.
I'm sorry, I said the UK.
The UK, the Wales.
Wales and
Wales. Your first point about not having sufficient comfort in certain jurisdictions, I guess if you don't think the courts are going to be fair or efficient, you probably also don't want to cite your arbitrations there, because if there's a dispute over particular arbitration issues, you may very well wind up in the courts.
Exactly, and the court may either be inexperienced and not know how to deal with this issue properly, or want to interfere with the arbitration, or be biased. And so it is best to cite the proceeding in a state with a well-developed and neutral arbitration law, such as the model arbitration law.
Or I think in Europe, for example, the two examples that are held out most often are France and Switzerland. They're two countries that have extremely well-developed arbitration laws. And the French, my experience these days are, the French courts in particular, if they see an arbitration clause, they want nothing to do with the dispute. They're very willing to kick it back to the arbitrators and let the arbitrators decide.
Although in one example, the French courts threw out an arbitral award where it was a multi-party case, and not every party was able to appoint their own arbitrator.
Which is a question of multi-party arbitration, or is something that you and I have talked about a little bit offline. Do you guys propose multi-party clauses or joinder?
We have never done that. The issue has not come up because we're simply at the end of the chain as the owner. But in some cases, I think it would be advisable. The issue is, how do you propose a multi-party arbitration without surrendering your right to choose your arbitrator?
Yeah, I think it's a tough issue. I think there's somewhat the appeal of supposing to simplify the proceedings, but I think this is one of those areas where, in trying to simplify, you really can run the risk of ultimately complicating the arbitration when it takes off. So we're very careful. I mean, when people have come to us proposing these joint or multi-party arbitration clauses, we've tended to very actively to try to discourage this, because we just think it's something that can lead to an unmanageable or difficult arbitration. The case you point out in France, for example, was one where the French courts, I believe, actually nullified the arbitration clause. They said, this is not a valid arbitration clause, therefore, as a result, you're in the courts.
Yeah. And I'm aware of the fact that some of your competitors also take a view against multi-party arbitration for the same reasons.
Okay. Well, for once, you folks may have found something in which we can agree with our competitors on. How many arbitrators do you? The numbers being usually 1 and 3.
Again,
1, 3, or 1 or more arbitrators, as some of the rules provide.
Hopefully not 2.
That's good.
Generally speaking, we prefer to go with a 3-member panel where there's a lot at stake, simply because we get the extra measure of accuracy in the result. We think that the deliberative process between the 3 arbitrators talking to each other about the facts of the law leads to better results. However, it also leads to delay, given that 3 schedules of very, very busy people have to be coordinated, and it certainly at least triples the cost of the panel. Thus, I think we would advocate a 3-member panel in large contracts that exceed $10 million. We may be willing to accept the sole arbitrator for any dispute under there, and certainly under $5 million, we're probably better off with the sole arbitrator.
Yeah, I think we're going in the same direction right now. I mean, the scary thing about arbitration, of course, is you don't have a right to appeal, so you're really at the the mercy of who the adjudicators are, but our experience is that the efficiency that you lose when you go to 3 is just not worth it in the smaller disputes. The 1 million, 2 million. I'd agree with you all the way up to 10 million. I might be willing to take it up a little higher than that and say that you're probably better off going with one arbitrator in those cases. They'll just go through things quickly. You can get much clearer decisions. But again, you take it with the risk that you don't have that deliberative process. I think that 3 arbitrators tend to also avoid extreme results. Whether it may be an extreme result in your favor, but it also may be a tendency to avoid taking an extreme position in your favor when you're right.
I think that's a very good point, that when you have a 3-member panel, they have to compromise. They really like unanimous awards, and so you are most likely to get an award that resulted from an agreement of everyone, including the other party's appointed arbitrator. It's going to be a less extreme, more conservative, more middle of the road award. Whether it helps you or hurts you depends simply on the facts of the case. But at the end of the day, it's also more likely to be a better reasoned, less extreme, more accurate result. And as you mentioned, because there is no appeal, the accuracy of the award, the accuracy of the process is paramount.
Yep. Well, let me ask also, we're talking a lot about arbitration. I think the one thing I want to make sure we didn't forget was mediation. I mean, you guys do much mediation? Are you in favor of it? Do you include the mediation clauses in your contracts?
We try to mediate as often as we can. Historically, we have not had mediation clauses in our international contracts simply because the area was just developing. I think that's the way of the future. That is, mediation clauses will get inserted more and more often.
Because arbitration is becoming so expensive, and it's almost like you can't not have
so
mediation.
Protracted.
Yeah. So you almost can't not have a mediation clause in your contract these days.
So I think international mediation is a developing field, and increasingly we will see mediation as a precondition to arbitration.
But right now you're not there. You're beginning.
Not there yet.
Yeah, I think we've gone down the path of beginning to put it in some of our contracts. But I'll tell you where we also put it, is where we have contracts where we may not be completely satisfied with the ultimate dispute resolution process, and we think that having mediation involved may create a further barrier between us and ultimately binding dispute resolution. It's a safeguard against, it's like a safeguard against having to be brought into the courts. It's a safeguard against having to take it to full arbitration.
And I have resolved many arbitrations in mediation prior to the final hearing on the merits.
That's right. Yeah, one of the escape things to point out that they're not incompatible. That they're complementary procedures, mediation and arbitration, as mediation and court litigation are.
That's exactly right. Okay. You can always arbitrate and decide to mediate at the same time.
All right. Well, listen. Thanks so much for taking this time. I really appreciate it.
You've been listening to International Dispute Negotiation. This podcast is presented by the International Institute for Conflict Prevention and Resolution, CPR. CPR is a membership-based nonprofit organization that promotes excellence and innovation in public and private dispute resolution, providing an international resource for the avoidance, management, and resolution of business disputes. For further information about CPR, or to download archived versions of this podcast, go to www.cpradr.org. Questions about this podcast or the issues discussed can be addressed to idn@cpradr.org. The music of Note Noir is used with permission.